Okay, good. Good morning. Very good to see this auditorium full. I'm just going to skip all my salutations and go right to the point so that we can get this seminar going. My name is Sheryll, and I teach the Law and Literature course in this faculty, and so this seminar is actually in line with that course. And before we start, please ensure all your devices are switched off or on silent mode. We have quite a bit to get through this morning, so let's start today's program. It is with great pleasure that I invite the Dean of the Law Faculty, Professor Dr. Jason Chuah, to start this morning's seminar with a few words of introduction.
Thank you, Puan Sheryll, Young Arif Dato Swee, Seng, and Young Arif Dato Azizul, Azmi, Adnan, judges of the Court of Appeal, Malaysia, Adjunct Professor Philip Koh, who is also Senior Partner of Kamaria Philip Koh, our Moderator and MC for today, Sheryll Stothard, who is also lecturer of law, or lecturer in the Law and Literature program here at the faculty. Dr. Izura Mastina Muhammad Zakri, Deputy Dean on the Undergraduate program, under which, of course, this seminar is organized. My colleagues, fellow academics, esteemed guests, visitors from Hong Kong, students, Tuan Tuan and Puan Puan, Salam Sejahtera, a very good morning to everyone. So I'm going to try to keep this quite short because you're here not to hear me, but to hear the panel of I was going to say esteemed, but I think that's an overused word, but very scholastic and intellectual minded panelists. Right. So the subject for today, as you can see, is the myths of metaphor. Figurative language in judicial reasoning. The context is quite narrow, but the subject matter is very broad. And I've been giving some thought to this issue of the use of metaphors in legal language. And I think this is a particularly interesting subject, but sometimes people might think that this is, well, is it not only of academic interest? Now, I would suggest that that is not true. I would put it to you that there is a much deeper sense and a much deeper context to the use and the understanding of metaphors in the law. Now, let me give you an example. And some of you would know that I am very much into legal history. And I'm looking at the moment, and please don't do this because I'm sure you'll be bored stiff, but I'm looking at the history of the indemnity clause. Yes, people want to look forward. I want to look backwards. And this is one clause which I found, and I'm going to read it to you, and I will do so in some deliberation because it is very, very long, and it's in language that you may find a little bit less than customary. The client agrees to shield, defend, and hold the provider harmless against any and all claims, damages, losses, liabilities, and expenses that may arise from or relate to the client's actions, omissions, or breaches under this contract. This clause shall serve as a lifeline, binding the client to respond to and cover any claims, thus allowing the provider safe passage through any legal and financial turbulence that may arise from the client's undertakings. Now, I also have the sad misfortune of teaching contracts drafting to my final year students. And I promise you that I do not recommend this form of drafting. But as a legal historian, I find these clauses extremely interesting because it gives you a real sense of, I suppose, the purpose of an indemnity clause. Because very often when we think about an indemnity clause, we don't think like that, do we? We just think, well, if I did something that is going to attract liability, somebody else is going to pay me. See? Very simple. Now, of course, I know we all belong to the plain English brigade. Nothing wrong with that. But sometimes, I think it's also good to allow our minds to wander a little and to meander into, now, of course, I'm sure you're picking up all the metaphors here, to meander into this rather attractive forest of figurative language. Now, having said all that as an introduction, you can, of course, see the tension between metaphors and, I suppose, legal realities. On the one hand, what you're looking at is a sense of, I suppose, a way of communicating that is quite powerful because you're using visual images or at least mental images. And I think imagery, it plays such an important part in the way we understand communication, the way we understand text. But of course, on the other hand, you're dealing with realities. You're dealing with hard, practical issues. So how do you make that connection between the two? Now, it may be suggested to some of us that there is a tension between the two. And I'm not so sure if that is a tension. I rather like to think of our way of communicating as something quite pluralistic, which means that it is perhaps not a tension, but it is actually a matter where it is perhaps horses for causes. Sorry for that again. That means that under certain circumstances, it may be useful to use certain metaphors, but not all the time. Then you will get an overkill. Apologies for that as well. But you can see how it can add to the way you speak and add to the way you communicate with each other. So I would rather like to think of this as not being one of a relationship that is tensed, but a relationship that can be complementary. But of course, it requires a great deal of discretion, a great deal of understanding in how we communicate to each other. Now, of course, then we also need to think about a cross-cultural context, don't we? Do these metaphors work? Does figurative language work in a diverse society, a multilingual society as the one we have in Malaysia? A friend of mine called Richard Trim, he's actually a world-renowned linguist, and he looks at the issue of metaphors, and he came to the conclusion that actually metaphors do work, and increasingly, do work in a cross-cultural context. Increasingly, we begin to see that even in different languages, we rely on figurative speech to convey what we actually mean when we use certain terminology. So I think, therefore, that this subject is not only important because it helps us look at the law differently, but it also posits, I suppose, the debate within our diverse society. And I actually think, therefore, the use of figurative language in legal reasoning, in judicial reasoning, can make the matter much clearer for the layperson. I went with the students to Putrajaya 2 days ago. Yes, I rode on a bus, and it was good fun. I think some of them can see it. And we had an audience with Tun Tengku Maimun, our Chief Justice. And she was telling us how important it is for judges to make sure that the language that we use is one that is understandable, one that is comprehensible to the lay. Now, to me, therefore, if we are able to make the language of the law a little bit more transparent, a little bit more comprehensible, I think that is a good thing. And if we can use figurative language to that end, why not? Right, so moving then to our speakers for today, I have given that, or rather I have been informed that the pleasure of introducing them will go to the moderator, and so I'm very jealous of her. But I will just allude to the fact that we do have two very prominent Court of Appeal judges with us today, and Dato Lee will be speaking on the Officious Bystander test, and Dato Azizul will be talking about the man on the Clapham Omnibus. And please, I know some of us don't even know omnibuses exist anymore, but there you are. And last but not least, our Professor Philip Koh will be looking into this idea of legal personality, especially the metaphorical corporate veil. And perhaps we can look at that, which of course a corporate veil is a concept which is now being used in various jurisdictions. And so you can see metaphors started in one jurisdiction can become prevalent in other jurisdictions. So with that, then I would like to speak on behalf of the entire faculty to thank our speakers for today for graciously agreeing to speak and take part in this seminar. Thank you to all of you for making the time to be with us today. Thank you very much.
Thank you, Professor. Now, I'd like to invite our three presenters to take their place on stage. May I invite Young Arif, Dato Swee Seng, Arif, Dato Azizul, Azmi, Adnan, who are both judges, Court of Appeal, Malaysia, and Adjunct Professor Philip Koh. Before I invite our first speaker, please allow me to kick things off with some Shakespeare. Always a very good idea in law seminar. This short extract is from A Midsummer Night's Dream, where Theseus praises poetic vision. The poet's eye, fine frenzy rolling, doth glance from heaven to earth, from earth to heaven. And as imagination bodies forth the forms of things unknown, the poet's pen turns them to shapes and gives to airy nothing local habitation name. That to me captures the essence of a well-written metaphor poetry. That the poet's power of imagination can give shape to airy nothings, to make concrete what is intangible and abstract, to give it a home and a name. In law, however, there is often a mistrust, metaphor. Not just Cardozo's warning about the mists of metaphor, but also judges closer to our time. Lord Hoffman, for instance, in the 2006 House of Lords case, Lawson and Serco, warned that, I quote him, experience shows that rules formulated in terms of metaphors always cause trouble when it comes to their interpretation. And the more striking the metaphor, the more likely it is to distract attention from the real issues in the case. The premise of today's seminar is to consider this very tension. In literature, embrace the distraction and imaginative possibilities of metaphor. In law, however, sometimes there is a resistance to the fact that you cannot nail down the meaning of metaphors used in legal reasoning. Metaphorical meaning shift, slip, and slide despite best efforts to contain it. So on that note, I look forward to hearing from our three presenters today on three very different doctrinal metaphors. First, Young Arif, Dato Swee Seng will present on the Officious Bystander. A few words of introduction before I invite him to start. Justice Dato Lee is a long-time friend of the law faculty here, having read law here, both bachelor's and master's of law degree. He was in active legal practice until his elevation to the High Court in 2010. In 2019, Dato Lee was promoted to the Court of Appeal. He is also known to us here in the law faculty for his support and encouragement of the law and literature course taught here. During the pandemic, Dato Lee graciously gave a full Zoom lecture to students on judicial allusions. And last year, he tackled Shakespeare's Merchant of Venice and money lending laws in a faculty seminar. We are very, very grateful that we have such a illustrious judge supporting our law and literature course today. As such, please welcome Dato Lee.
Thank you, Sheryll, for the kind words spoken about me. Part of it written by me. As Dr. Jason Chuah, Dean of the Law Faculty, whose judgment is my tutor, lecturer in contract law when I was at law school here. So, coordinator for the course I took for my year professional practice course. I got an A, but I only got 2 A's throughout the whole of my law career. So it shows how bad a student I was. But when you go out to practice, ask for your grades. So, you just have to do your best in practice. Don't go back, just forward, because that's what life is designed. That's how life is designed to be lived forward. Now, let me say that I was never a formal student of literature. So whatever I learned of metaphoric expression, figurative language, I probably pick it up along the way as I read law reports, law books, and other that I could put my hands on. So I must begin at my level, which is very, very low level, as to how I approach this whole concept of the use of figurative language in law. One guy stated that we could hardly speak some 20 to 25 words without using a word in its figurative or metaphorical sense. So go back and the experiment and see. Good. We were just having a chat, Professor Dr. Jason, and every now and then, yes, we came across figurative expression. I guess it's part of the way we have been brought up, and every language would have its figurative expression. When my granddaughter say my big day is coming, she's probably saying, oh, it's a great day coming, not as in the size of the day, though she will have many hours to be packed to that big day. And so we do that without ever thinking about it. And don't ask me for the difference between what is a metaphor and what is personification, or what is analogies, what is hyperbole and all that thing. We know a thing used in the figurative sense without knowing the finer shades as to how it is been called. There are PowerPoint some. Oh, not here. I was thinking of a less obtrusive way to say next, and it means I touch my thigh. It means we have gone past that. Right. Now, I guess we all move from what we know to what we not know, but try to understand and try to explain it to someone else. And so the use of metaphor in that sense bridges the gap between what I call the actual and concrete, that which we can touch, handle, and that which is abstract and conceptual, that which we cannot touch and handle, but no less real. So sometimes I ask my friend, which would you see better, with your physical eyes or by closing your eyes and trying to see what you want to see? You can do that experiment for a while. And some people say, when I close my eyes, less corruption, there's interference, I see. And perhaps that's why we use figurative language, because it helps us to see things more vividly when we cannot see things physically out there. How does one see justice? How does one see equity? For all concepts, we can only see the results or implications of it, but we cannot see that thing itself, because that thing is a little bit abstract and conceptual, but no less real. Now, I guess in law, more than in any other field of human endeavor, we would come across more figurative language and metaphorical expressions. And my own theory is this. You talk to a doctor. I went for a colonoscopy the other day, and the doctor say, if I see a cyst, I cut it out, and then I'll send it for examination to see whether it's... Uh, nothing very much figurative about it, because you can actually imagine the physical act of cutting and putting it under the microscope and examining it. The same with an architect who have drawn a plan, because everything is created twice, they say. So first the thing exists in its mind and it's used into writing in plans, and then someone comes along and construct it. And so they deal with things that can be touched and handled. Whereas we as lawyers deals very often with concepts and abstraction, and therefore we employ more figurative language and expression than any other profession, I would say, save for, of course, those who indulge themselves in literature. So in law, we often talk about the brooding omnipresence of the law. It sounds nice, seems something hovering over our head, follows us wherever we go, and so that sense of being everywhere. And so we get a nice feel about it. We used it to express that the law is everywhere. Balancing the scale of justice, because sometimes one factor tilts it this way, another factor tilts it the other, and we are trying to consider a multitude of factors to make the scale balance. Sounds nice. Why don't we use it? Opening the floodgates, we can imagine the force of water rushing down, and that kind of thing. Perhaps over-exaggerated, but sometimes exaggeration is good. No foul hand shall touch the pure fountain of justice. The pandemic, they say, must wash and wash and wash our hands for how long? Until we can sing that must rhyme and whatnot. But then when we touch something that is pure, perhaps we contaminate it. And so it's a beautiful expression. I still remember when I first came across it, I say, beautiful. Something that is built, sit back, we admire, relish it, and moved on. Now, the purpose of metaphor, it creates apparently an immersive experience and helps the reader engage with abstract principles. I often relate this to what I see when I see some video presentation. Lately, I've been watching and listening to novelists being interviewed. And one of the most comforting tagline was what one novelist said. I've never come across an author who has no problem writing. I felt so much comforted because I have to struggle with every one of my judgment, even though I have written on that same area of law a couple of times before. And one of them say, you must show, not tell. And so I asked, what's the difference? And they give examples. She was angry, that's telling, right? But if you want your reader to be able to imagine better, you say something like, her face turned red, she clenched her fist, glaring at him with fiery eyes. That is show. And I guess in law, when we narrate facts, we use quite a couple of figurative expressions because we want to show more than just tell. Tell is very plain. Show, put yourself in that particular environment. Anyway, this example is taken from, I think, Copilot. So I don't know if you Google it or whatever, you get the same answer. I asked, give examples of show rather than tell. A few examples came out. This is one of them. So I confessed. I acknowledge myself. Now, now the law introduces this man called the man. And I was very surprised, and I did a quick research through my research assistant. I said, how many statutes we have? She says we have about 1,000. And how many of these statutes contain the word reasonable? Or half of them. And so the conclusion I come to is this, that in our legal training, more than in any other training, we go through life learning what is reasonable in the situation we find ourselves to be in. And that's the whole training of law. It teaches us how to come to a reasonable conclusion or decision based on the facts that we are confronted with. And so sometimes we infuse this imaginary character with all kinds of traits. Different people say different things I've come across. Some say he's a considerate man, not selfish, not apathetic, not easily excitable, not easily angered, not biased. Some say not open to scandal. Others says no fixation with conspiracy theories, etc. You know what I mean? Is the kind of ideal person. We're just trying to discuss how we should decide in one defamation case. In that case, the person was not referred to by name, and so what is been said about him, could a reasonable person think that it would refer to him? But more than that, could a reasonable person in that particular industry would know about him? And then we came to our conclusion. So many a times we put ourselves into the shoes of this reasonable man, and at the end of the day, we find ourselves being the reasonable man that we try to imagine exists, and what would our answer be? So one example is in the case of Morgan and Adams. The other is the law of negligence. How would a reasonable person respond in circumstances which someone perhaps had been injured and want to stage a claim for negligence, for instance, the neighbor principle. Yes, we have to take care of our neighbor, love him the way we love ourselves. And also in the law of nuisance, we find that again the reasonable man is being featured. We assess whether or not the interference with another use and enjoyment of the property is reasonable or unreasonable circumstances of the case. And even in criminal law, we would come across the reasonable man, because we have to answer the question as to whether or not this private defense that has been used is something that arises under a circumstance in which this person would be placed in reasonable apprehension of either danger to his body or to his safety, etc. And then we move on to the Officious bystander test. It first appeared in the case of Moorcock. It was a case where a ship that was berthed at a jetty was damaged because I think there was low tide, etc. And so the ship owner sued, and the court says, let's apply what is called business efficacy test. And if we need to import this term into the contract, the island, then we import it to allow for business efficacy. But looking back, you can also equally argue quite convincingly that at the end of the day, it's a matter of apportionment of risk, isn't it? And so if the parties had not addressed this particular risk, why can't we let the damage lies where it falls? And full stop. Or do we then say, for business efficacy, is it effectiveness, is it efficiency, whatever it is, we need to import this term. And if you do so, you'll be running foul of that principle that normally we would uphold freedom of contract and we would not rewrite the terms for the parties. Anyway, it seems that that test was proposed in kind of an extempore judgment, but whatever it is, it has its enduring effect, and we have been using it to this day, the business efficacy test. And then there is the Officious Bystander test, which came perhaps a bit later. This man was appointed a managing director by the company for some, I think, 10 years or so. But later, another group of shareholders took over controlling interest in the company. Some terms of the articles of association of the company was changed. He was terminated. And the question is, when your contract says work for 10 years as MD, can the company later, exercising its rights under the company law with respect to articles of association of the company, terminate your employment? And so the law lords decided, and by a majority they said, we use the officious bystander. And how do we apply this officious bystander test? We asked the officious bystander the question, if the parties, when they were negotiating and bargaining the terms of the contract, had this question raised, you have terminated him earlier, they would have said, no, of course, for 20 years or 10 years as the case may be, during that time, he could continue to be the managing director of the company. Now, we have to then ask ourselves, the question has been asked by the officious bystander, but he doesn't answer. The parties to the contract would answer. And when they answer, it has to be the same answer. It's not a case of one saying yes, the other case no. Both of them should agree. So tell me, is this a subjective test or is this an objective test? Because it's not stated very clearly. Justice Pei Siu Ching in one of our decisions in Sabah Bumi says subjective test. How many of you say it's subjective test and objective test? Subjective test, raise your hand. Objective test? Some hands. If you want more time to think about it, raise your hand. Ah, no, okay. You don't want to be labeled as a slow thinker, I think. Now, so it's easier asked than it is answered. So one day I was looking at the thing, and it was in the context of a derivative action, apparently objective test, as to whether this particular shareholder has intended to commence his action bona fide, bearing in mind the best interest of the company. And so I said, it's a subjective test, objectively determined. The fact that it is objectively determined does not convert the subjective test into objective. Now, does it make it more confusing? Looking back, perhaps I shouldn't have said that, but I was trying to analyze it. How does one objectively determine what is essentially test by putting oneself into the shoes of the person supposed to give us the answer? But be that as it may, it helps us to visualize the thing better. But then you cannot just say the answer would be this. You have to support your answer with why you say this person invariably, or both of the contracting parties invariably, would say, of course, this term is in the contract. So this then is the problem. And when we looked at what Justice Andrew Pang had written, he seems to suggest that at the end of the day, the implied term is a device that is utilized by court in arriving at what is perceived to be a just outcome. So in short, at the end of the day, you just want to arrive to a fair, reasonable, just conclusion. And of course, you have to support your path and route to that decision. So you utilize at times perhaps the business efficacy test, and at times perhaps the officious bystander test. And then there are others who come along and says, let's granulize it. In other words, let's dissect this officious bystander test. What elements go into it? And so in the case of B binary, what we have is this judge telling us, Privy Council, that you ask the question, is it reasonable? Is it equitable? Is it necessary to give business efficacy? So they're importing the business efficacy test. Is it so obvious that it goes without saying? It looks like they're also importing the officious bystander test. Is it capable of clear expression? and it must not contradict any expressed term. Perhaps that exercise tells you that it's not just one question which you have to answer. Your mind goes through processing factors that you take into consideration. And so with the case of Marks and Spencer and BNP Paribas, very interesting case. Among other things, this was a lease agreement, and so it provides that if you want to be able to terminate the contract before it expires, then you pay 1 year ahead for every year. And so what Mark and Spencer did was they pay ahead, and then later they say, we want to exercise our right to terminate the contract by giving a 6 months notice. And they say more than that, the unexpired 6 months, we can claim back the rental. Then the other side, landlord says, no, you can't. What is paid is paid. And so it came before the law lords, and they says, yeah, there's no need for us to imply anything. The contract is clear. You pay 1 year ahead, give yourself benefit of early. If you want to exercise that right, or you give the landlord. Nobody talks about the rental paid for the unexpired period. I was telling myself, well, is that a case of kind of a penalty clause that is been used against you because you complied with the law and yet you have to suffer 6 months of unexpired rental paid in advance, forfeited? Perhaps that could be raised as an argument. Sure. Now, as we look into this various tests, another test more lately by the Privy Council in the Attorney General of Belize case and Belize Telecom. And at the end of the day, they said it is a question of interpretation. Oh, why did it take people so long to discover that? And then they say a reasonable man faced with this contractual terms, how would he have understood it? He being a person appraised with all the facts and circumstances of the case. So it's a question of interpretation. And the next slide tells us that there are certain things that must be borne in mind. You don't introduce a new term to make the contract fairer or more reasonable. In other words, you are faithful to the principle that you don't rewrite the contract for the parties just because you want to make it fair. And then the default position is you don't imply any term. It is for the court to interpret the terms of the contract, and we all know interpretation of contract is a question of law. Not a question of fact, it's a question of law, apparently. So you don't have to ask the parties, what were you thinking of when you put in these terms? Because for the court to interpret what the party had intended by reference to the meaning of the words, natural and ordinary meaning, and words as used by people in that particular trade. And then it says that the contract must be read as a whole, etc. So, as I was trying to ask the question, is this test a new test? Or is it a case where the previous tests have been substituted for this test? Has it been subsumed into this test? Is it supplemental to this test? Or how do we consider this test? So a lot of ink has been spilled as to whether or not when we apply the Officious Bystander test or the business efficacy, does it involve interpretation of the contract law? Some people say, yes, there is an element of interpretation when you have to consider implication or the exercise of applying a term into the contract. You cannot but try to interpret the contract. But those who go on the strict interpretation view would say, we interpret the contract by reference to the words used. So if the words are not there, how to interpret those words that are not there? So it looks like default position for those who stick to this theory would be that if a term is not there, we would be very slow to import that term. But perhaps what we can do is to interpret that contract holistically and see whether it could yield the meaning that you want it to yield, respect to what has happened, what should the consequences be. Now, my time is up, and so what I've left with problem question, and I have a first problem. That first problem is taken from a case that is reported, and perhaps you can apply your mind to it. Lecturers can change the facts a bit to be a problem question in your exams. I do not know. I'm not giving you any hint. I got no control over what comes out in the examination. But it's an interesting point because it has happened before. Someone is employed by a company. He has been terminated. He can go to the industrial court and ask for reinstatement or back wages for wrongful termination. If his areas of salaries have not been paid, he can go to the labor court, he can go to the civil court and sue for damages, etc. And so can you then raise the argument, hey, look here, I cannot employ him because in reality, in one case, he was a refugee. Another case, he was an undocumented migrant. And so can you say an employer that employs him be guilty of a criminal offense, and so the contract is void for illegality? But then when you look into the Industrial Relations Act, when you look into the Employment Act, does it say expressly that the court has no jurisdiction merely because you have a valid work permit? That kind of stuff. And some people even argued Article 5, don't care how he entered the country, so long as he is in the country, he has a right to life. Right to life involves, among other things, a right to seek employment. And in this case, he was employed. We let the criminal law deals with the criminal aspects of things, but here we are dealing with the contractual aspects of things. I'm not sure. So when we use the expression, if something is contaminated at source, it will be contaminated along the stream. How far do we stretch this analogy? So if the stream is very far down from the source, perhaps the contamination has been so diluted that it's no more contaminated. And so we won't import illegality into this kind of contract. Then I have a second problem, but time does not permit me. And at the end of the day, I think, last slide, we don't have to overanalyze the use of figurative language in legal reasoning. I think if something expresses a concept well, knowing and acknowledging the infirmity and limitation of words, take it for whatever it is. Sometimes judges use it when they narrate facts. In this case of Teotihuacan, a case of Lady Godiva riding down the horse on Cap Gome night. Well, it helps us visualize the thing better. Or a principle of law, something that is so obvious, you don't need an expert to evidence on that. Quoting from a song, that you don't need a weatherman to tell you which wind, which direction the wind is blowing. Perhaps that illustrates it. I want to thank you for listening, and I want to end with this quote. A lot of us are very kind of fixated to looking good. So I leave this with you. If you have good thoughts, and all of us have good thoughts here, they will shine out of your face like sunbeam. That's figurative expression. And you will always look lovely. So thank you all lovely people for listening.
Thank you, Dato Lee, for yet another very engaging presentation. I'm sure the audience will have questions, so please save them for the Q&A session. We'll move on to the second presentation. Our next presenter is Yang Arif Dato Azizul Azmi Adnan, who is currently Dato Lee's colleague in the Court of Appeal. Prior to his present role, Dato Azizul served for 9 years in the High Court of Malaya. Before his elevation to the bench, he practiced law, worked in an investment bank, the IMB, I think, and also with the Securities Commission in its early days. His lordship is the only one on this stage who did not read law did not study in Universiti Malaya. Dato Azizul read law in Cambridge. And Dato Azizul's daughter is also in Cambridge. She managed to get into Cambridge. It's getting more and more difficult. So that's quite an achievement. I had proposed this topic of the man on the Clapham Omnibus to Dato Azizul, partly because I was inspired by his coining of our own Malaysian version, the man on the Cheras MRT. In his 2017 judgment in the High Court defamation case of Dato Sri Anwar Ibrahim and Khairi Jamaluddin. This is one of my favorite judgments because there are parts where His Lordship's crisp and cool analytical style can be used as in my class, in my literature and law and literature class, as an example of masterful, close reading analysis of text that we strive for in the best of literary criticism. If you want to look for the case, I'm referring to paragraph 10. Please welcome Dato Azizul, who will take us for a ride with the man on the Clapham Omnibus.
Thank you very much. Introduction. I should start by recording my thanks to the faculty. Very flattering to be invited to present. And it is such an honor to be here to present to you today. Thank you also to Emily Lai, who greatly assisted in preparation of this presentation. I would like to correct Sheryll as regards to my not having studied in I did my CLP in 1992, and as a consequence, faculty has a very special place in my heart. So this is the reason why I'm here. This was a claim by the present Prime Minister against the then head of UMNO Youth for a statement that he had made in the course of a political rally. The statement was found to be defamatory, therefore I shall not republish them here. The gist of the statement was that it connoted that the plaintiff was a homosexual. Now, this was what I had said. And the defense, one of the defenses was that, look, there was another meaning of the word. What the meaning that he had intended was that the plaintiff was a backstabber. He was in the habit of playing out his political allies. And the let me press Siri here. So what I had said was the statement to the effect that the plaintiff is in the habit of playing out his political ally would not be considered by the reasonable man, the hypothetical man on the Cheras MRT, to be defamatory of the plaintiff. The keen observer will of course note that there is no such thing as the Cheras MRT. As you can see in the little graph at the side, the Cheras station is on the Sri Petaling LRT. In my defense, however, the green line on the right, the MRT line that actually passes through parts of Cheras. The expression, the hypothetical man on the Cheras MRT, of course, traces its existence to the man on the Clapham Omnibus. And it appears to have first been in Judicial Expression in 1903. This is the quote from Maguire against Western Morning News. And the way that it was used by the Court of Appeal was in fact by way of exclusion. The Court of Appeal said essentially that when you consider the fairness of literary criticism to disregard the opinion of the reasonable man. But of course, that expression itself has somehow morphed into being a doctrinal test for the reasonable man. And the expression was attributed to Lord Bowen. And if you go through judgments made by Lord Bowen, there was no record of him having used the expression. The second interesting thing is that if you look at the picture on the slide, that at the material time, there were no omnibuses in Clapham. Clapham was serviced by horse-drawn carriages that predated buses. The fact that the word used is omnibus shows you how dated the expression is in the first place. Why Clapham? Clapham is apparently representative of an ordinary portion of South London. Clapham is just south of the power station, Battersea, just south of Battersea. Of course, now it's getting very gentrified. Yeah, if you have ever been to Battersea recently, the development by Khazanah, it is very, very impressive. His other claim to fame is, of course, being on the cover of a Pink Floyd album. The expression is, of course, a metaphor for the ordinary reasonable man. And what is a metaphor? The expression metaphor comes from the Latin metaphora, which in turn comes from the Greek metaphorian, which means transfer or transform. And the Oxford English Dictionary defines a metaphor as a thing considered as representative of some other, usually abstract thing, a symbol. So in context, therefore, the expression metaphor is a figurative representation of the ordinary right thinking and reasonable man. Some other examples of the ordinary reasonable man include the following. These are the expressions that have been used in jurisdictions outside of them. In the case of Tong King Chai, Madam Justice Faiza Jamaluddin said as follows here. In my view, the ordinary reasonable man, when the statements were published, would be the man or woman traveling on the Kelana Jaya LRT or the Ampang LRT who is fair-minded, not avid for scandal, not unduly suspicious, with ordinary or average intelligence. In Hong Kong, the judgment in Incorporated Honours of Shatin Newtown against Yung Kui, the judge stated as follows: the quintessential reasonable man on the Shao Ken Wan tram, bound to wonder. And this was in the context of the construction of the terms of a contract. What the parties would have meant by the terms in the contract. In Australia, in the case of Papatunakis against Australian Telecommunications Commission, this was in the context of a care. The standard of care and foreseeability of injury which the law exacts of him are not those of the hypothetical person on a hypothetical Bondi tram. The Bondi Beach in Sydney used to be serviced by a tram. This case was in 1985. The last tram that serviced Bondi Beach was in February 1991. So even by the time the judgment was written, it was already outdated. That is a picture from the Bondi tram when it was running in the 60s. The man on the Clapham Omnibus is an example of what can be termed doctrinal metaphor. A doctrinal metaphor can be described as a legal concept dressed up. Other examples would include piercing the corporate veil, Chinese walls, the context of insider trading, or the eggshell skull rule. The metaphor because the skull obviously is not made out of eggshells. In an eggshell because it is unusually fragile. And the principal advantage of a metaphor is to bring an abstract concept, to bring into being abstract concept, to manifest what would otherwise be imperceptible into a three-dimensional shape, mind's eye. So for this reason, it is useful because it can aid understanding, and for a judge, it helps frame the question addressed. Its use, however, is not without criticism, and problems arise when the use of metaphor hinders proper understanding of an expression of an abstract idea. So it is useful to a certain extent. It is useful for you to perhaps grasp the concept, but where it fails is when you try to define exactly what the elements contain in that. So that is where you need more precise language. You have to beware. The reasonable person does not always ride on the Cheras MRT. And the conception of a reasonable man, in fact, I would probably say that we should use the expression reasonable person instead. I try in my judgments to use the more neutral gender. And by way of analogous illustration, this is the judgment of Chief Justice Thompson in PP against Muhammad Ali. Those of you who have done criminal law will be familiar with this quote. When a police witness says something that is not inherently improbable, his evidence must be in the first instance be accepted. If he says he saw a cow jumping over the moon, his evidence is of course not to be accepted. But if he says he saw a cow wandering along one of the main streams of Kuala Lumpur, the sort of thing we see every day of our lives, there is not the slightest justification for refusing to believe him. Yeah? So this is the credibility of a police witness. Of course, if a police witness came to court today and said that he saw cows in the street of Kuala Lumpur, you wouldn't believe him. Yeah? So in the future, the mode of transport of the ordinary person may well be different. And that is a picture of Kuala Lumpur. And if you look at the building right at the top right-hand corner, up in the hill, that is the old Supreme Court. I think before was probably built in the 1800s. That is where Maybank is now, which used to be called Bukit Mahkamah. I came across this photograph purely by chance. Now, in the context of an action for libel, what if the publication was made, say, in the Age Financial News? The average audience of the Age may well not be a purveyor of public transportation. So you can see how the concept of the reasonable man can change depending on the context. The reasonable man the reasonable person who reads the Edge may well live in Damansara Heights. And in the context of a point which Dato Lee had touched on earlier, the reasonable person can be someone imbued with special knowledge. In the case of Napfer against London Express newspapers, the plaintiff was not identified by name. So the question was, could the defamatory statement be referable to the plaintiff? Would a reasonable, but here the test is, have to consider and imbued with the special knowledge of being acquainted with the plaintiff. Not just any reasonable man, but a reasonable, right-thinking individual who knew the plaintiff. Would he have understood defamatory statement to be referable to the plaintiff? And the final example here is in the context of insider trading. In insider trading, one of the elements that must be proven is that information has a material effect on the price of the securities in. So, person must be in possession of material non-public information. Either traded that information, sold that information to. He knew that information was not public, and information would have had real impact on the price of securities. So the materiality of that information is determined by reference person. But it's not just any reasonable person. It is a reasonable person who invests in securities. And I would say maybe one step more, not only invest in security, but invest in the security similar nature as those that are the subject of the dispute. So here again, the reasonable person might well be the person who lives in Bandar Utama or Tropicana or somewhere like that, rather than anywhere else. And finally, I would just like to make the distinction between doctrinal metaphors, which we have seen earlier. Those are the metaphors that are used to describe legal concepts. By contrast, there is something called stylistic metaphor. And stylistic metaphors can be used and they provide room for creative writing. Here, I'll give you some examples of how I myself have used stylistic method. In the case of Cik Suhaimah Mat Saman against Sergeant Shafinas, this is a judgment that has been delivered but not yet published, yeah? Delivered to the parties but not yet sent to the publisher. And this is what I said. Even a cursory examination of the plaintiff's pleadings will leave the reader with the distinct feeling that counsel has decided to adopt a shotgun approach to the plaint, spraying his buckshot wide and far in the hope that one or more of his pellets will find its intended mark. So this is what you may call an extended metaphor. It paints the picture of someone indiscriminately raising allegations that in the course of trial was found to be baseless. Here is a tip if you are writing for submissions or if you find yourself on the bench and writing a judgment. Save your stylistic metaphors for the end. There's a good reason for this, yeah? As a judge, or even as counsel, have to maintain a degree of objectivity, and you let the facts speak for themselves. So lay out the facts, get the reader to understand the facts, you have your conclusion, and then you provide your commentary on the facts. This is where the emotive language comes in, and this is where you allow yourself to give a more emotional response to the facts of the case. Here's another example, a more prosaic example perhaps. This is Mercury Securities against Concrete Parade. And the issue here was whether the shareholders' circular that had been given to the shareholders constituted appropriate disclosure of the transaction that the shareholders are asked to approve. This is what I said. I said that you have to read it as though in the context of a reasonable man, yeah, a reasonable investor reading it, would he have understood it? Yeah. So that was the test. And the commentary I provided was the risk of any other approach would be to cause shareholders' circulars to grow into an impenetrable legalistic thicket of words, capable of comprehension only with the assistance of legal advice. So the image that is conjured in your mind's eye is like a beluga. Yeah? You cannot even begin to understand it unless you take a parang and chop all the things that are obscuring your view and your way. Now, having said that, so stylistic metaphors are useful. It gives the judge an opportunity to give an expression as to his emotions, yeah? But for that reason, it is also to be used very sparingly. Only in the appropriate cases, and often less is more. And the final piece of advice I would leave for you is to avoid cliché at all costs. That concludes my presentation. We'll be happy to take questions at the end.
Oh, that was really such a treat. All the students, I'm sure you all enjoyed that. First of all, before I go to the next presenter, many apologies. Actually, Dato Azizul did tell me he did it still. But, you know, I think I just got dazzled by Cambridge. So you had me at Cambridge and then that's it. I just couldn't think of anything else. So sorry. Our next presenter is, of course, from this faculty. Mr. Philip Koh has been adjunct professor here for the last 3 years. But actually, he used to teach here, as Dato Lee has pointed out. Before he went into legal practice as a young graduate, Philip taught law here in the early 1980s. Before he passed the main responsibilities of teaching the law and literature course to me, he was the lecturer for this course. Personally, I have known Philip Koh for 30 years now, and I consider him a close friend and a very supportive mentor. Philip is quintessentially an intellectual first, a lawyer second, and I mean this as a compliment. I'm sure people who know me know that I'm giving a very high compliment. His reading is formidable, and his love for literature inspires me in my own journey in law and literature. But today, Philip has chosen a weighty topic, not one but two metaphors, legal personhood and the corporate veil. I invite Adjunct Professor Philip Koh to the presentation.
Thank you, Sheryll. It's very chastening to come after two learned judges who late Ahmad Ibrahim told me when I was a young, I counted him and said, it is unjusticiable, big word in international law. Then he looked at me, entered young student, of course, grasp. I think I see graduates like you learn so much from station, argumentation, still mind pen. We academics at hard and like my practitioner friends would say, too academic, right? We make no apology for that. The dean and I watch for academic while looking at the realism of legal. We have heard. Well, it's not this minor finesse. Implication must be advised just and the heart by all of us like to luxuriate in our language. I chose this topic of corporate personhood. I thought of my own journey in corporate law when late Michael Lim taught me and thought that I'm just a general, probably not passing the exams. Tired by that criticism, I went to King's College in London School of Economics, and company law, Lord Wedderburn, right, the great editor of Gower. Of course, that was a very humbling experience. After time, I don't know what this Welsh professor was going on, racing through the secrets of the act. Coming back to practice and moving between three worlds. Law firm for 5 years, publicly. Boardroom, gestation with shareholders. That was fascinating. My journey. I have three loves in life, right? In law, contract law, as institutional law, which is turning into Abdul Qadir mission, judgment of judiciary, when he says double trouble, right? And the late Azmi said, "Wow, Macbeth, you stupid." A little bit harsher. Tend to be. Today, my topic is more mundane. About is about the official person or my life. My PowerPoint, less I. Lord New Berger is fine decision by federal court led by Justice Laney, the way of academic writings. Voila, there is a learned judge in the court. Written. The survey of academic writing say current imposition in metaphor have resulted in doctrinal mess, he cites. Academic writer, access view, then court. Berger cites, of course, Cardozo quote, right, rather pejoratively. Cardozo rather observe that the myths of metaphor in company law start by deliberate thought and often by unleaving it. Then I picked up a recent symposium, not that recent, published in a book called Narrative and Metaphor in Law, brilliant book, where author very, very playfully say, as Justice Cardozo said that, look at what language he used. Advises deliberate thought, then end up enslaving it. Perhaps just that comes under your stylistic metaphor. Right? Very helpful distinction that just much as you may decry doctrinal or dogmatic metaphors, and our lives are replete with those metaphors. Rational law of checks and balances, structure, state compulsory RAM, prismatic interpretation. All right, a list gesture of strategies and the judges like engage in, try to listen to our voluminous, often exhausting and exhaustive questions. Brings me to a great classic case of common law. The Solomon edition, I want to skip to Solomon now. And it's very interesting that locus of legal personhood was established in 1890. There, I would like to urge every student of company law or any law, read all the judgments, right? High Court, Court of Appeal, laws. You say, oh, we can survive reading a case note, right? Or head note. And we have a PowerPoint and take away. And I would to say my favorite quip, no power with the point and point with the power. Right? Age in the close cases. And the fascinating point about Solomon when I read practice, didn't understand it when I was undergraduate. I'm still trying to understand it now, right? And I'm now 17, right? Here we have John Williams, great commercial judge who wrote bankruptcy, High Court, saying that Solomon tried to limit his liability actually to give indemnity to creditors. Because he found that as a kind of a sham, vice, hide behind, sort of ring fence the creditors, but that's not his word, right? Then you have the Court of led by Lindley, pushover, right? Not one of those airy-fairy judges who, in the academic world, one who wrote Lindley on ownership, pushover and commercial judge. And yet, he, together with a very learned court of judges, set aside the complications in the whole process of Solomon, led by brilliant chancery lawyers, perhaps, who advised him, Mr. Solomon, your boot making somewhat dangerous. It's new. Holiday. Hide behind it. Not only that, we will create a debenture. You charge the yourself, so you can have the first secured claim on the assets. Wow, this is stuff, all right, for undergraduates, maybe read that. And then when he went into trouble, told the charge, Mr. Broderick, all pretty Jewish names, all right. As I read it, I said, there's some whiff of anti-Semitism here. All right, that's a loaded word now, I know. Still, interesting enough for me, when I read Lord Lindley's on William's decision, I would like to use Alistair Hudson, a great comment. Alistair Hudson, one of the very good law professors and teachers, he observed in a very interesting book that he wrote called Understanding Company Law. Make no bones about it. Books like that actually are not that simple to read, but Alistair makes it simple. And basically, says, as you observe the House of Lords reversing corporate personhood principle in terms of how the High Court and the Court of Appeal pierced the veil, even though they didn't, and allowed the creditors to claim against Mr. Solomon personally, he said that it's fascinating. He looked at the House of Lords here in close analysis, argues that Osbury and McNaughton, with the other fellow judge, was entered not to give explanations of why they did so. Just say, Parliament has decreed now 7 shareholders. So what if 6 of them are his family members? Majority of shares is held as the 7th shareholder. So what if he create a limited liability? Birthing of this behemoth known as corporate personality, done out without any explanation. Professor Hudson hazarded a guess that Victorian morality that informed both Vaughan Williams and Lindley's bench made them, well, the Parliament never intended corporate form to be sham, vice, the words that are used, and therefore establish once and for all one of the greatest company migrated across USA and the whole of the country, including of course Malaysia, where our Companies Ordinance Act 95, Act 26, a privilege of doing the law reform on, adopted. Not only that, in 2016 we allow a one-man company entity. No more even 7, which disturbed the Victorian lawmakers. Now relate to the topic part of my lecture. Metaphor of the veil. When Lord Newberger introduced Crest and Petrodel, a marriage family law case where one of the grief women tried to remove the veil from the husband that owns numerous assets and property in England. It does not need us to go down into the details of the family law dispute. For us, company law lecturers and practitioners, Newberger and Lord Sumption highlighted that the doctrinal view of piercing corporate veil is erroneous. Essentially, if I borrow Azizul, very helpful, that we must not elevate metaphorical expression, a doctrine, because can mess up our legal judicial analysis. Not Newberger, notwithstanding his desire, narrow down all those cases, and when you look back at all the host of cases in England, which have been cited in Malaysia for our Ong and Keller case, he argues that none of them need to be placed on the doctrine of piercing. But he still hazards 2 principles: evasion principle, a concealment. Of course, main citadel and principle that he cites comes also from Lord Denning in a very major case where he says that there is fraud. Everything can be unraveled. Actually, very interesting indeed. But concealment and evasion principle became part of the attempt of Lord Newberger and Lord Sumption, framing and in granularly, borrowing, but unpacking this idea of piercing the veil, the exceptions, fact of limited liability. Lord Windeyer, in a vision, the learned, did say that heuristic controversies about corporate personality and its derivatives today seems to me at times worrying. Any linguistic expression has been used to describe this entity. Hate, ham, God, vice, legal fiction that drives us into waters of legal history, right? Remain and fiction. You're interested in continental philosophy, which I have on. Bahinga's as if, right? As if it real, and therefore the actual debate into deep philosophical ground what is actual, real, what is fiction. Younger LJ has long ago said also that use of words like simulacrum, sham, or cloak, another polite term of invective that failed to apply judicial application of interpretation of facts in the statute under consideration. Lord Magneton, and that's a judgment all of y'all should read, Facts of Solomon, right? Which sound like Lord Denning or Justice or just simplicity, which he described of Solomon as cited unlimited. Lord Magneton cried the use of expression like one man company. Taking a nickname does not help us much in the way of argument. But Justice Azizul has advised lawyers get here online, careful, don't get carried away, nicknames and cliches, right? What is a metaphor? And here I engage in a bit of my philosophical rumination, picking up a book on new rhetoric written by Occidental thinkers. Metaphor is an analogical fusion, all the functions of analogy itself. In respects, it works even better, strengthens the analogy. Thence, metaphor integrates into language, but it's only by awakening the metaphor and isolate the structure. After this, outstrip analogy. But the critic, writer of this great volume called New Rhetoric, says criticisms on this one hand can use all the devices available for rejecting the analogy. In addition, it can often object to the obscurity of metaphor. A newer work by a great Scottish jurist, Neil McCormick, Rhetoric and the Rule of Law, Oxford book, says that legal argumentation is in the nature of forensic persuasion. So using figurative language may help you in that, but it can also obscure, if a very sharp judge like our learned judge here, they point out beyond your nice language, you show me the facts that argue, right? UK Supreme Court unease over the critical question of lifting the veil can be instance of concern to my mind, all right? Rigor of legal reasoning and interpretation may lapse from the confusion of the genres, i.e., careful judicial evaluation of facts and law as to whether, as a matter of correct principle, limited liability immunity is to be. I will close now. This is Nalini facing the case in Ong and Keller, held on the facts and rising facts case that a certain individual, Ong, has in fact layers of company, and there is an evasion of liability, not wish to pay certain contracting parties, right? And basically, federal court took the opportunity of adopting reasoning of Lord Sumption and Lord Newburn. But even within the learned federal court Justice Nalini, there is a struggle, right, to see whether or not the evasion or concealment principle articulated by Lord Sumption and Lord Newburger to help us. I quote favorite poet, some of us, T.S. Eliot, there is a rest words and meaning, try to find fair answer facts, all of it. Last philosophical point I want to make, Judicial work, relationship. Perhaps I should read that and the PowerPoint. Think about it. There is this struggle as we look at, even in Solomon case, the fact of a sole property known as, where does that boundary, his obligation to pay creditors, hiding behind it, like himself. That decision reverberates now, giving rise to our capital markets. I enjoyed your reference to Chinese wall, right? The phrase actually, if you look at the CMSA, capital market, like I'm very familiar with it, practice in SC. But Chinese wall is not there. Secrecy arrangement, right? And we all know on that Brunei case, KPMG, how flimsy Chinese walls may be torn down, right? And firms try to use. So whether it is Chinese wall or the reasonable man, recently Daegu invited me to, and we talked about security, a judgment that took 20 pages, 100 over pages of Court of Appeal reversing you, and 200 over pages of Justice Nalini again, reversing the Court of Appeal and re-establishing 20-page judgment. Quite an achievement, right? So for me, humble practitioner in this, navigating the shows of literature and actually a passion, I always wanted to do literature, passion, and then I need money. So, but the reversal takes place. Miss Sheryll Stothard so energetically in this, got first class in English literature. I got a second upper in law. I come back to literature. Then she took law 3 years ago and got first class. I said, my goodness. So I quickly handed the course to her. What better choice have I made? I don't need any figures of speech for me to endorse her course. I hope that you have enjoyed this thing. Happy to take questions. Figures of speech will ever be there, whether in Simpan Bahasa, poetry, perumpamaan, all right? They all are part of bird, child, forever be discounting, describing. Thank you very much.
Thank you, Adjunct Professor Philip Koh. I'm going to pick from here because we're going to go into a Q&A session. I think we do have some time. As I think, where are my students? Can you all just, my law and literature students, put up your hand? So now you can see that luckily you have me, not Professor Philip Koh, who makes you read 3 cases, very long cases. I just give you one short case, right? Please finish your today is the deadline, please finish. I noticed some of you didn't finish. It's a very short case, lovely case. There's no excuse, huh? I think 5 pages, was it? 6 pages, yeah, so get it done. All right, sorry for that, I just have to remind them of the deadline. Now, For this session, if you have a question, please identify, just say who you are and where you're from. Hmm? Yeah, okay, and the mics are over there. So we can try to get through some. Keep your question short and sweet as possible. Thank you.
Okay. Hello, everybody. My name is Chuah. I'd just like to thank the panel. And congratulations to back. Yeah. In those days, no such thing as literature and the law. Great fun. So very good. Cambridge was not offered either, right? Just is it offered? Literature and the law? No, I don't recall. Definitely no such. Congratulations. Quick question. Again about I went to prosecute parent trust, PMF, spent many prosecuting complex commercial corruption. First instance, fine. Had lots of argument about. I was a bit upset. I said it should be ethical, about ethics. I mean, so anyway, I've been talking with all my former colleagues. They agreed with me that somehow stuck in depression, but is used spend many. So really, it's just the views of the one American judge told word Chinese really what he flotsam. Flotsam means floating rubbish, not the use metaphor, but derogatory thing.
Thank you. I don't disagree with your sentiments. The reality is that, first of all, I don't think it is meant to be meant to be insulting or denigatory. Perhaps it is intended to refer to the Great Wall of China. Okay? So you have a very secure partition to keep the barbarians out. But the second observation is that regardless of the appropriateness of the word, it is very difficult if you want to explain the concept. Okay? You have to explain it as secrecy arrangements in an organization to prevent the flow of information from one part of the organization to another. There's a very long sentence to describe the concept. So you have, in this case, it's the metaphor is used to describe the concept. Yeah, it is a labeling metaphor. You use it just to label it. Of course, it doesn't explain what exactly. What it means is that, oh, you must have in your organization procedures that can reasonably be expected to prevent the flow of information from, for example, your advisory division, where you're advising a client on a corporate transaction. You prevent that information from flowing to other parts of your organization, such as your securities trading division. Okay? So it's simply actually a labeling metaphor. It's useful because I can just use 2 words and everybody knows what I'm talking about. But it is not useful because it doesn't describe what it actually means. So this is where the struggle between precision and being able to quickly understand what a concept is that tension between. Okay? So metaphors are very useful because they allow us to quickly understand it by way of an analogy, but at some point it breaks down. At some point you have no choice but to revert to precision. That's my 2 cents.
To add to it, there are 2 interesting cases cited, the Bolkia case and KPMG. And there's a Hong Leong case, not quite reported, but in Philip Billy's book, where these Chinese walls are described as too flimsy. All right? I share his view. And I remember I was in a finance economist, law and economics conference where corporations are discussed. And interesting enough, derivative action, someone mentioned it. And also class action. Up jump a Chinese representative. Class actions? Heard of it? The party that can do class action is the CCP. All right? Communist Party of China. It's class action, no such thing. All right? Anyway, these are part of the intercultural engagement when the Anglo-American dominance of corporate law, capital markets, are hitting the ground. These are the floor. Evergrande, Vietnam, the woman is going to be taken out to be shot. And I have a question from Miss Stothard posed to me. Since I'm holding the line, I'm sorry, I will finish that. It's interesting. I was thinking of it because I was in Lord Cook's residence, UK, for a function. I wandered into a room and I picked up a 1910 The Accountant magazine. They say there's no insolvency law in the Chinaman jurisdiction. Very term, Chinaman, right? They just march you up into a boat and shoot you and just drown you, right? As to company law being passed in China, I was drawn by that. Here's the corporate veil. We all know that you can drive a coach and horse through any corporate veil.
I was just listening to the analysis of Trump's victory, and someone says he coined the word the China virus. You know what I mean? So if you just look at it as in he thinks it originates there, nothing derogatory about it, but something that is said so often becomes the truth, perhaps. I think there is this tension between precision and picture. And when you look at a picture, you can look at it from so many different perspectives. If you say the law is an elephant, you know, you can have a blind man feeling the elephant and says the elephant is like this, the elephant is like that, and the other thing. And so we cannot stretch analogy to its limits because it's bound to break down somewhere. It's just an analogy. It is like, it is not identical to. And sometimes you have to use a few metaphors to try to more accurately explain and emphasize and enhance certain aspect of your abstract idea or concept. That's how I put it, because it is not something you can touch, feel, and handle. It is hovering up here, and that's where analogy comes in. I remember theologians debating on what's the best analogy for Trinity. One says water, eyes, and was it vapor? Then somebody says, no, God the Father cannot become God the Son and God the Holy Spirit, as water can become eyes and vapor. It breaks down somewhere.
Okay, thank you very much. Before I ask for the next question, I have to address what Mr. Philip Coase said. He jumped the gun there. I had asked, I want to ask him a question. The question was actually looking at the reforms in China's Company Law Act, where they put into statute this whole veil piercing. So what I had said is because they extended liability, the veil became a fig leaf. So it just ceased to be. So that was the question. And you just go and look up the Company Law Act in China. Okay. Maybe this lady over here, Amir.
My name is Amirtha. I'm currently a CLP student. Firstly, I say thank you to all the panelists. Really enjoyed your speeches and your explanations. My question is directed to Arif, Dato. My question is, do you agree that the officious bystander is in reality the judge in that particular case? That said, how can the metaphor of the officious bystander aid the court in deciding whether there is a true gap in the contract to be filled by way of implication? Thank you.
It's a fiction. Sometimes I wonder whether it's a true story fictionalized or a fiction or non-fiction kind of thing, you know. If you can just think for a moment, which is which. Now, when we imagine an officious bystander, of course we can ask that same person who has asked the question to answer the question himself. Nothing wrong. Huh? But apparently when it first started, the test was the officious bystander asked the question, and the two parties to the contract, assuming there are only two, they are the ones to answer. So somebody says Lord Hoffman was wrong when he seemed to have stated that it was the officious bystander who answered. But I think we don't have to really speak hairs over that. But the whole device is that you created this fictional guy and you make him ask a question, and that helps perhaps a layman to visualize it better. What is it that you're trying to? And then he might say, that doesn't make me find the answer much easier. Well, that could be true, but I was more than comforted when I came across a quotable quote by Steve Jobs. And he said this: if you ask the right question, you almost normally find the solution. And I was struggling at that time with adjudication. You know, the Construction Industry Adjudication and Payment Act. They say what is important is for the adjudicator to ask the right question. Doesn't matter he gave the wrong answer. When I first heard that, I said, hey, how could it be, you know? But then I began to comfort myself. It's a decision of temporary finality. That poor man has done the job. He has expended time, energy, and money. Just pay him first. The final thing comes later at the trial or at the arbitration. And then I say, yeah, when you ask the right question, most of the time, you're able to arrive at the right answer. So if the officious bystander had asked the right question, wouldn't the parties have thought about this? That's a question. They addressed their mind to it. Perhaps that gives us closer to the answer. I don't know. Huh? Then at the end of the day, it's the judge that decides what answer to give. And so he would close it, this, that, and the other thing. But he's trying to arrive at a reasonable, fair, and just. That much I can say because my puny mind cannot process more than that.
Okay, thank you. I think we can take two more questions. So which one? Which of the gentlemen? Okay, all right.
Thank you. My name is Isaac. I'm a member of the public. So I would like to quote, no foul hands shall touch the pure fountain of justice. So I have two short questions. I noticed quite a number of lawyers, right? they lie blatantly in the court. And then I try to ask the judge to take action, or at least uh, reprimand them, or maybe like give them some warnings. But then sometimes the judge, they just smile at me like that. So my two question is how to make sure the judge will take action to stop those lawyers and their clients from perjuring, lying in court. And second, let's say if the judge does not take action, so that means the judge is quite breaching his fiduciary duty. So how to take action against the, let's say the judge is a judicial commissioner who does not enjoy the same immunity as a normal high court judge. Yeah. So two questions. One is make sure the judge will take action to stop the lawyers from lying. Second is if the judge does not take action, what happens? Thanks.
Thank you. It's a really good question. This has to do with the goodwill of counsel with the court. Yeah? Lawyers are officers of the court. How I think of it is as follows. Because a lawyer is an officer of the court, when he appears in court, automatically has goodwill with the court. And the goodwill starts at 100%. Okay? The judge takes the view that the lawyer is being less than honest, either in the presentation of the evidence or in his articulation of the legal principles, then that goodwill starts to erode. How, me personally, how I would deal with it, then I would become very wary of whatever he is saying. I will not take what he or she is saying at face value. I will definitely check. It says that the case says a particular thing, then I will check. In fact, does the case actually say that what he says it says? Yeah? And there is also no assurance that the judge hearing the case will not note your name down in his little black book, and the next time he has lunch with his colleagues, he shares the contents of that little black book with his fellow judges. I'm not saying that happens, but I can leave you to speculate. Now, going back to the gist of the first question, how does a judge deal with it? Yeah? If you've read some of my judgments, you know that I deal with it in my judgment. I will say, for example, in one case, I said that, yeah, I understand that you have a duty to advance your client's best interests, but you cannot allow your moral scruples to slip. I address it in the judgment, yeah? So by doing so, the message that I am giving to the industry is, the moment I take the view that you are less than honest, for me, I will call you out in my judgment. What's the second part of the question again?
The second part of the question is, let's say if the YA, because it's a real case lah, one of the judicial commissioner in KL High Court, right? He purposely go and shoot the opposite counsel, and then he also tried to protect the tampering, because there was a tampering of the affidavits. Because what I did that time, I was filed the affidavit with the exhibits in color, but then when they scan, right, the version in the court becomes 100% contrast. That means it's black and white only. You cannot see the face at all. So then the Timbalan Pendaftar, right, she tried to strike out our case based on the black and white. So actually it's a tempered evidence, a tempered affidavit. So we raised this to the judicial commissioner. The judicial commissioner.
Sorry. I think we are going
yes. Okay,
into
sorry.
areas which is very difficult for our
it's difficult for us to comment on the specific merits of a particular case. But what was the principle that you wanted to
The
me
principle
to
is,
address?
let's say if the judge did not take actions or take note of all these irregularities or illegalities, what are the consequences for the judge?
The consequences for the judge.
Yes. Because it's very obvious that he is protecting them.
Okay, fine. The fundamental principle is that a judge, whether judicial commissioner or judge, he is immune from liability in the course of making his judgments, making his determination. Because only with that can a judge decide without fear or favor. So the Court of Judicature Act provides for the immunity of judges. That includes judicial commission. So your recourse is, if it's the council think had committed an offense, make a police report. 2 is, and complain to the Bar Council. If you think that your case was meritorious, take it up on appeal. Those are the 2 courses of action you must.
Okay, thank you. Okay, I think you can take one last question. Can I please ask you to stick to today's topic? Any one last question? Oh, Rama. Oh, okay. I'm going to ask a non-lawyer friend of mine. So I'm cronyism here. Rama.
Lose my balance. All right. Thank you very much for. I have a question. I write about things that out is cases. A couple. Type of said in that police sweep thing. And how that I or such a question. Legal person. Leave that with.
Well, I haven't really particularly thought about it in that fashion. I suppose if I use a figurative expression, I would try to use one that is non-controversial and that is not racially or not racially biased. So I avoid that. But for cases of public interest, generally, summary is released to the press on the and that summary would kind of distill the essence of the case and easier for reporting purpose. But if a reporter wants to just focus on one particular aspect, I suppose that's within his freedom of speech, I guess, so long as it is done with a good taste or whatever, not to extremes. More than that, I haven't been confronted with the situation where it was blown out of proportion, at least for my judgments. other people's judgment, I'm not too sure. I can't remember particular examples, but as you said, there was one involving the Coogan's case. Not personally aware of that.
My short answer is no. My audience, when I write, the audience that I have in mind, so it's important to have in mind your audience when you are writing or presenting, right? My audience, the first person in my mind is the appellate court that is going to read my judgment. Yeah? So and I know they're very busy, they don't have time to read a treaty. So I try to communicate the ideas as simply and as directly as possible. Then the other audience, the lawyers and the litigants. So again, the same objective. Communicate the concepts as clearly and as precisely as possible. You want to include a bit of flair and style, that is fine, but it cannot be to the extent that it obscures the primary objective of writing.
Short comment, outsider from the judiciary. Judiciary forms a major organ of constitutional framing. Their articulation, either in private or public law, engages citizenry, people, and the constituents. In that sense, I think the two learned judges shared there. But I think more and more with more learned community or fluency, they do expect a reasoning that can satisfy what I would quote John Rawls on the bar of public reason. At the end of the day, winner or loser will have something to say about why they did, right? But the bar of public reason must, I think, if they're dissatisfied, they have done their communication of it, reporting are part of this. Thank you.
Okay, thank you very much. Sorry, we don't have enough time for too many questions. I always thought that judges, when they write not to be reversed by the appellate court, it's very constricting, I think, right, on a first instance judge. But never mind. Thank you again for staying here. Just before we end, I would like to invite our Deputy Dean of the Undergraduate Program, Dr. Izura Masdina Muhammad Zakri, to just deliver some closing remarks. This seminar is actually under the auspices of Dr. Izura, her program.
I'm not going to give a long closing speech, but first, of course, I would like to say that this was originally meant for LIA 3022, but because the topic was just too interesting, the STEAM panels are too great, we just had to share it with everyone, especially my. Okay, well, so thank you, Prof, for the course, and Miss Sheryll, who was actually all the backbones struggling, meticulous planning, and to the students and staff as well who actually helped the background, and of course, last but definitely not least, our esteemed, I will use esteemed and distinguished relatives, but Yang Arif, Dato Lee, and Yang Arif, Azizul, and of course Prof Philip, for braving the fields and meeting everyone and putting the law, contract, tort, and company law into a perspective that is completely different from those thick textbooks and hopefully not so boring classroom. Right? So you can actually see it from a different perspective. And that's what we actually want. Primarily from the law and literature course with Prof. Philip introduced, and what we hope that all our students get. Even though this is a topic for the second semester, we will ask you in second semester how much you reckon. Okay, so other than that, I would also like to thank Arifs that they're not just willing to come here for speaking at this course, but also they're willing to actually contribute in a much more deeper meaning, which I cannot reveal at the moment, but hopefully later on. Right. So thank you very much for that. And yeah.
Okay, thank you, Dr. Izura. Don't leave yet. We're just going to have a bit of a photo session. Do you want Prof. Chuah and Dr. Izura to be on the stage first, or we go and take a picture there? Okay, all right. We'll just move over there and see.